very much to everybody for signing into today's webinar, which is managing long-term absence. If you do have any questions or you want to make any comments, then please feel free to put them into the chat box and we can address them either as we're going along or at the end. I'm joined today by Nathan Andrews. He will introduce himself now and we'll start the session. Thank you.
Hi everyone, thanks for the intro, Joe. Some of you may have attended previous sessions that I've facilitated before, but my name is Nathan. I'm the managing director of a consultancy company called Okana, and we specialise in employee relations management. So we do lots of ER case management, working with client organisations on various HR and employee relations issues that they need support with. So today Joe's asked me to come along and talk to you about managing long-term absence, which is one of our favourite topics. We're dealing with a lot of long-term absence at the moment. What I'm going to do is just share my screen and I'll bring up my slides. Joe, can you see the cursor moving?
Yeah.
Perfect, you've got the right screen. There we go. So can you see my slide? Yep. Super. Okay. So without further ado, I will launch into what we're going to talk about. So what I'm going to do is focus on things that we consider to be key components of an organisation's approach to how they manage long-term absence. So the things we're going to look at will be defining long-term absence. We'll talk about some general approaches to absence management as a whole, and that can include your approach to short-term absence, because short-term absence can actually often be a precursor to long-term absence. We'll talk about sickness records, so gathering accurate information as part of your approach to managing absence. We'll then look at reviewing absence. We'll talk about policy and procedure. We'll also talk about obtaining medical advice, accessing medical records, long-term illness dismissal, and we'll touch on disabled employees as well as part of our discussion piece today. Now, what I will say is managing long-term absence is quite a broad topic. There's often lots to it. So this will be a whistle-stop tour of our approach to being effective at managing long-term absence. I won't necessarily be able to cover everything. Typically, if we run training seminars on this topic, they can last half a day. So we haven't obviously got that much time. So I'm going to give you the headline stuff and hopefully it'll be useful information that you can take away with you at the end. So the first thing I want to do is just to talk about how is long-term absence defined? Now, most of you, I'm sure, will know that typically long-term absence in most organisations is defined as an absence of one period of absence lasting 4 consecutive weeks, and that is in line with the Institute for Health and Care Excellence. That's the National Institute for Health and Care Excellence, often defined as NICE, and they define that long-term absence is a one period lasting 4 or more consecutive weeks. Now, I work with lots of organisations who actually go one step further and define their long-term absence as being one period of absence lasting 3 consecutive weeks. And I'm actually often a fan of using the 3-week as a benchmark, because I think the earlier you can start managing long-term absence, the better it is for the organisation and for the individual. Now, what we always say when working with client organisations is that be specific and take into account the needs of your organisation and the context of your organisation when you look at how you want to define long-term absence. 3 weeks for me is reasonable. If you want it to be 4 weeks, that's fine. But my preference always is set the benchmark at 3 weeks, and that means that if you know someone's going to be away from the business for 3 consecutive weeks, you can start to take steps to manage that in line with your internal policies and procedures. So just touch on general approaches to absence management, and this can also include short-term absence, because often I find, certainly when we work with clients, that they can overlook short-term absence as being a precursor to maybe longer periods of absence. Often when people are taking frequent periods of short-term absence, it can give us clues that there might be underlying health issues that we need to be aware of, and that can help facilitate us asking the right questions early on. So the first thing we always cover up with clients is that you are not, there's no prescribed way of measuring and monitoring absence, you can choose the processes and procedures that you want to have in place within your business. All that we would say in that regard is that you must make your employees aware of any company policy or procedural rules that you have in place which apply within your business. And it's absolutely important that you, if you do have those internal policies and procedures set out, that you apply them consistently. Now, ideally, any absence policies and procedures will be non-contractual. That's the advice we give our clients. If you have contractual absence policies and procedures, and we work with clients that do, it is really important that you then apply those consistently, because if you breach a contractual policy, it leaves you open to a potential claim for breach of contract. So that's something we always talk about when we work with client organisations. But on the whole, your absence policy should be non-contractual, and that should give you some flexibility if you weren't to follow it to the letter. That being said, if you have a policy, our recommendation is always apply it consistently and you can't go wrong. One of the things to look out for if you're not applying your policy consistently is that can often give rise to claims for discrimination and unfair treatment. So it's really important that you are familiar with your absence policies and that you are consistently applying them across the board with everybody. Now, absence typically falls into two common themes. So you have persistent short-term absence, which is often referred to as people throwing a sickie, or you have the long-term periods of absence, which are normally brought on by chronic conditions or serious illnesses. Now, the only caveat I would say to that is, in terms of these two common themes, is that it is important to remember that sickness absence isn't always as a direct result of physical problems. Mental health is a big issue today, and that can often lead to things like stress and depression and bipolar disorder or anxiety. These are things we can't see, but we need to be aware of. In addition to that, when we talk about mental health, you often find employees may well be suffering with stress, depression, anxiety, etc., and haven't talked to you about that, because even though we are getting much better at talking about mental health in the workplace, I think there's still more to be done. And often we find employees, when we're working with clients, you often find employees aren't always comfortable with sharing concerns or issues with their mental health. Now, I do want to just briefly touch on the disability provisions which are set out under the Equality Act. I'm not going to cover the Equality Act, in any large amount of detail due to the time constraints of today, but the important things to remember are essentially it is unlawful for an employer to discriminate against a disabled person in relation to their employment. Now, the Equality Act specifically says that a person is disabled if they have any physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. So that is the measuring stick we use when we are talking about employees who are potentially disabled. So when dealing with sickness absence issues, particularly those that are long-term, it's really important that you don't inadvertently fall into a situation where you discriminate against your employees. Now, this is most likely to arise in our experience where there are disabilities or pregnancy is involved, and so it's you need to be cautious if you know that someone has the possibility of having a disability or that they are pregnant. So as you will all know, employers have a duty to consider and, wherever possible, make reasonable adjustments if they are aware an employee is potentially disabled or could reasonably be expected to know that an employee is disabled. So that is something you need to bear in mind when you are managing long-term absence. If you don't do this, you do risk a claim being made to the Employment Tribunal for disability discrimination, which is something you want to naturally avoid. Finally, in terms of pregnant employees, so employees who are pregnant are automatically protected from pregnancy and maternity discrimination. So you can't hold any sickness absence caused directly as a result of pregnancy against the employee or dismiss them because of it. Again, if you were to take such course of action, you would find yourself potentially defending a claim in the Employment Tribunal, and the award is unlimited for compensation with those particular claims. I hope that all makes sense. So move on to my next slide. So sickness records, this is something we spend a lot of time talking to our clients about, which is often when we have clients approach us with issues or concerns around absence, is the first place we go to is what information have you got, what records have you kept? So if you want to manage absences within your organisation and be really good at doing that, then you need to keep consistent records of any absences as and when they occur. Some things that we always say should be captured, and I'm sure you're probably all doing that as a matter of course. That being said, we work with client organisations who sometimes aren't capturing this information, and it's really difficult when you're wanting to manage absence when you don't have the relevant information that is needed. So we always say you absolutely want to capture dates of absence, so the absence start date. Obviously later on, when the absence has ended, you want to put in the correct end date as well, so you can then calculate the number of days absent. You want to capture reasons for absence. Again, we've touched on it, the length of absence, and it's often helpful when an employee is reporting in sick to ask them, are they aware of how long that they are likely to be away? So for example, somebody might phone in with a cold and you know that reasonably they're going to be back within a couple of days. But if somebody is phoning in with, say, mental health issues, it could be that they're going to be away for an extended period, and that may fall into long term. So it's good to understand from the employee's perspective, how long do they think they're going to be away from the business? The other important thing to capture is any comments made by the employee when they're actually reporting in sick. So if they make any comments that might be a flag for you to think about in terms of stress, mental health and well-being concerns, capture that information as it's communicated to you. And that's also really useful when you hold a return to work interview, to be able to draw back to that information and to essentially do a welfare check when the employee is back at work. Again, we've covered off likely return to work when they're reporting in sick. It's just really helpful for you to be able to manage your resources while an individual is away. Now, in terms of evidencing absence, if an employee is away from the business on long-term absence, so again, let's think about if we go with the 4-week benchmark, if they're away from the business for 4 consecutive weeks, that's long-term sickness absence. As we all know, an employee can self-certify for the first 7 days of absence. Thereafter, they are required to provide evidence, and that would typically be in the form of a GP fit note, or it may be a medical certificate from a hospital if they're having treatment under a consultant. But typically, you should be asking for a GP fit note if they're away from the business for longer than 7 days. What you can then do when they provide that sick note is take a copy, give the original back to the employee, because they need to keep the original in case they need to make any claims for benefits, etc., while they are away. Keep any copies of medical certificates on their personnel file, and again, you can refer back to this when you are holding a return to work interview when the employee returns. Now, I just want to touch on return to work interviews, because these are really important and really helpful, certainly when you're dealing with short-term periods of absence that might give you a red flag that there are ongoing health issues that you need to talk about and be aware of. Now, when conducting return to work interviews, I think it's really important to record clearly what was said during that meeting. Is the absence connected to any ongoing health issue? Explore that with the employee. Don't be worried about asking questions, because all you're wanting to do when you're holding a return to work interview is to gather facts and information so that you can then be in a better position to support the individual concerned. Other things you need to cover are, does the employee expect there to be an ongoing issue which will impact their attendance at work? Really helpful if you can gather that information. Does the employee anticipate needing the business to provide them with any support? Could they benefit from meeting with occupational health, as an example? And once you've gathered that information, it's really important to type that information up into your return to work form, print that, you sign it as the person holding that meeting. If it's not you, it'd be a line manager. So get the individual chairing that meeting to sign off that return to work form, and then pass it to the employee and ask the employee to sign as well. Give them a copy for their own records. You keep a copy for the personnel file. Really, really important to gather as much information when you're dealing with absences, both long-term but short-term as well, because what you can do is you can draw back on that information that helps you build a picture of what the issues are and of what you need to do next when you're managing absence.
Nathan, there's 2 or 3 comments. Are we all right to just go over them now, or do you want to just wait till the end?
No, you can go over yet.
Okay, so Jill's asked, I think we struggle with reasonable adjustments. So say, for example, you have an employee who struggles with dexterity in a factory with timings on their production assembly. How low are we expected to go to reasonably reduce these targets so that someone could return to work? We assume that that employee is possibly disabled.
Okay, I mean, look, I think if you've got a genuine business need for employees to be able to achieve certain standards and you can objectively justify that, then it might be that you're not able to make reasonable adjustments. And if you can justify that you can't and that it's reasonable not to do so, then that is absolutely fine. It's just about the process of mapping out the business need for you to hold the boundary on your targets, if you will. So there's, you're not obligated to make reasonable adjustments if you cannot. The obligation is to make reasonable adjustments if you can. So go on, sorry, Joe.
No, go on, sorry, carry on.
Yeah, so my view would be, again, you need to weigh up your business need. Is it reasonable for you to require employees, say working on a factory line, to achieve certain targets? And if you can't accommodate a lower performance, a lower standard of performance, you need to be able to justify why, what impact will it have on the business, the operation of the business, etc. I hope that answers your question.
Sharon's asked, does the medical condition have to be diagnosed in order to make specific workplace adjustments?
Not necessarily if you're happy. I mean, we've recently worked with a client where an employee's had has claimed to have a health condition, and the client organisation was saying, look, whilst we haven't had a formal diagnosis, I'm happy to make adjustments. And they did so. What I would say is, if an employee is saying, I've got a medical condition, you absolutely want to have some kind of evidence to support that diagnosis. So it'd be reasonable for you to ask them to give you access to their medical records, so where you can approach their GP, for example, or you might make a referral to occupational health. But ultimately, it would need to be the GP if they have a diagnosed medical condition. So I would say you would want to have evidence of that, because it might be that you need to look at longer term reasonable adjustments, and also whether you can make those reasonable adjustments or not over the long term. Does that answer the question? I hope it does.
I'll come back to the others after Nathan. I'm just conscious of time, but there is some other stuff in the chat there.
Yeah, fine. Okay, I'll whistle through slides and we'll get to the questions. Reviewing absence, again, I'm sure all of you know this as HR professionals. It's really important to review absence consistently and proactively, with the ultimate aim of facilitating an employee's return to work. Ultimately, what we want to do is to get an employee who's on long-term sick leave to come back to work, fit and healthy and able to make a valid contribution as they were before they went on sick leave. What we always say is regularly review absence across the whole workforce for both short-term and long-term periods of absence. This should form a regular part of your, I would say, month-end activities. I would always say to any client, run, if you've got, an HRM system in place, run absence reports, make sure you're checking who's been away from the business, make sure that return to work is being done consistently. Ideally, the line manager should be doing the return to work. It shouldn't sit with HR. Sometimes it does. If it does, fine. But if you can get your line managers to hold those return to work interviews and get them trained to do a really good job, that's really important. Regarding long-term absence and conducting reviews, what we always say is it's really helpful if somebody's on long-term sick leave to conduct any reviews in conjunction with occupational health and the employee, get the employee involved as early as possible, so that you can get their input and their feedback. Sometimes we deal with cases where things have become contentious and difficult and the employee is resistant to having any involvement. And yes, you do need to manage that situation, but wherever possible, get the employee involved early on and make sure that they know that your approach to managing their long-term absence is ultimately aimed at getting them back to work fit and healthy. And the key starting point to that is to contact the employee as soon as you know their absence is going to fall into long term, and that should then trigger your long-term absence policy. Get in touch with the employee, have a meeting with them. You can meet with them on Zoom, have a telephone call, make a home visit if necessary. But the aim of that early meeting is for you to understand what's going on for them, and to understand whether you can make any adjustments to support them, so that they can get back to work. So there are 5 key steps I'm just going to quickly cover with you, which is managing employees' absence should be carried out proactively with the aim, as I've said, of getting the individual back to work. To achieve that, you should carry out regular reviews with them while they're away from business. You want to be concentrating on the length of their absence, so keep in touch with the individual, making sure that they update you if their absence is likely to be ongoing. So, for example, if a medical certificate is due to expire, make sure you're touching base with them before that expiry date to ask whether they feel that they're going to need to be signed off again for a longer period, for example. Talk to them about their general health and what they believe their recovery period is likely to be. Speak to them about their readiness and ability to return to work. These are obvious things, but really important to cover off. And also make sure wherever possible you can put together a mutually agreeable plan that helps the individual to come back to work. And I say this deliberately because I deal with lots of clients who, I think through frustration, want to manage the employee out of the business, because what we say is, no, let's work with getting the employee back to work where they can start contributing again to your organisation and your team. Primarily, it is the line manager's responsibility to have involvement and to manage the process of meeting with the employee. You're there as HR professionals to support the process, to provide advice on policy and procedure, but ultimately you want to empower the line managers to have involvement for meeting with the employees concerned. Okay, let's move on. So in terms of policy and procedures, I always say it's really helpful to have a short and long-term absence policy. The short-term absence policy is obviously there to cover those sickies, as we call them, those frequent short periods of absence that people sometimes will take. A long-term absence policy should set out very clearly your approach as an organisation when dealing with someone on long-term sick leave. I will quickly run through what we would consider to be the essential component parts of a well-drafted long-term absence policy. So you would want to have a general intro. Your policy should set out the scope of that policy. It should explain the employee's responsibilities. You should cover off the processes you'll take when needing to gather medical evidence, the framework for staying connected during long-term periods of absence, provisions for sick pay, what happens with holiday during long-term sick leave. You need to cover things like occupational health, and it's typical for long-term absence policies to have a framework where there are triggers that are put in place, where you might have triggers 1, 2, and 3. 1 being where someone's absent for 28 calendar days, right through to trigger point 3, where someone's been off for much longer than that, and you are potentially considering dismissal. You would also want to cover off an appeal process in your long-term absence policy, and make cover provisions for return to work arrangements and return to work meetings. So that's the framework of a good, well-drafted long-term absence policy. Again, I appreciate I've flown through that. If you have any questions, feel free to get in touch with me by email, and I'm happy to provide that framework to you, so you can look at maybe drafting your own policy if you don't have one in place. Very briefly, just covering obtaining medical advice. So as soon as you're aware that a period of absence will be long-term for an employee, it's preferable to refer them to a medical practitioner for an assessment as soon as possible. You will want to decide on whom you're going to instruct to do that. Typically, when we're working with clients, our first protocol will be the GP. If we feel that there is ongoing concerns either through a diagnosed condition or the possibility of the individual being disabled, we would write to the GP and ask for access to their medical records. Now, there is a specific process that you need to follow, and I will cover that off with you on the next slide. But just to be clear, I would always suggest, if you have someone that is on long-term sick leave, early on, get as much information as you can. If that means going to the GP and getting information in the format of a report, perfect. Because what you can do is, when you get that information, you can use that to help you decide what you need to do next. So I've briefly touched on the last slide around access to medical records. So employees do have rights. I'm sure you already know this, but employees do have rights under the Access to Medical Reports Act, which was written in 1988. And essentially those rights are to be informed about their rights under the Act itself, to have the right to decline to give their consent to a report being prepared, to ask the doctor for a copy of the report before it's issued to you, to ask the doctor to amend the report if in the employee's opinion it is inaccurate or misleading, and also to give them the right to refuse to allow the report to be released to their manager. Now, I would also say that a checklist for requesting medical advice from employees' doctors should consist of writing to the employee and asking for their written consent for you to write to their doctor, informing the employee of their rights under the Access to Medical Reports Act. And then I can't actually see on mine, because if I can move, I've got the screen in the way and it won't say my other notes. Bear with me. Recognise the employee has the right to decline. So you want to acknowledge that when you write to the employee, enclose copies of the employee's signed consent when you write to the doctor, and where the employee wishes to see the report first, inform the employee that you have made an application to the GP. What I'm going to do is just reshare my screen. Let's do that from the beginning. Can you see my slides, Joe?
I can see your screen, but it's blank. It's just blue. All right, got it.
There we go. Cool. I've got a line from Zoom that goes right through the middle of my notes, so for some of them you can't always see. Right, we are nearly there. So long-term illness, I just want to briefly touch on that. It is important to deal with all cases of long-term ill health sensitively and with compassion. And I say this purposefully because I appreciate when you're dealing with someone that's on long-term sick leave, who may have had prior to that frequent short-term periods of absence, it can be quite frustrating when all you want is that person to come back to work and to make a contribution to the business as they were before they went off sick. So where you are considering the status of an employee who has a long-term illness or appears to, you must absolutely investigate the situation and obtain a medical opinion as to their current and future capability. That is really important. You want to do that before you make any decisions about what you want to do next. You should discuss the employee's capability with them. Again, that's really important, especially once medical evidence has been obtained or you have had a request refused. So if the employee refuses to give you access to either their GP or to attend an occupational health referral, you need to be meeting that employee and discussing that with them. And that's essentially to put you in a better decision as to what you need to do next, and also whether that employee is likely to return to work in the near future. Excuse me. So very briefly, dismissal. And again, we've dealt with a couple of cases recently. It is usual where an employee has been away from the business for an extended period for the organisation to consider dismissal. And that can be an acceptable outcome as long as you have followed a fair and reasonable process and there's no reasonable expectation of a recovery. And for you to make decisions around that, you do really need to get medical evidence to support that view. And what I would say is dismissal on the grounds of incapacity is a statutory fair reason for dismissal, which falls under capability. Capability is one of the 5 fair reasons for dismissal. Now, what I won't do today, because I'm conscious of times, I won't go into that in any real depth or detail, but we can take questions afterwards. But I'm happy if you have questions, if you want to contact me by email, I'm happy to answer them for you. So just briefly touching on disabled employees. So if you have an employee who is disabled, then you are required to make all reasonable adjustments to facilitate their return to work. If you can't make reasonable adjustments, you've got to be able to justify why. So that's what I would say on that point, is that links back to the question earlier. If someone is disabled, we are required to make reasonable adjustments where we can. And if we can't, we need to be able to clearly set out the reasons why we're not able to do so. Finally, you also need to consider whether there is a suitable alternative employment opportunity if you have a disabled employee who can't carry on in their current role. So you would also need to look at, have I got any suitable alternative opportunities where the employee can still remain employed, but in a different role that they can actually fulfill. And that is around really essentially avoiding any possible disability discrimination claims being made to the employment tribunal. Excuse me. And that is the end of the presentation. I feel like, again, I've tried to kind of fly through a really meaty topic, so I'd welcome any questions.
I'll just go back to a couple of the earlier ones, Nathan. So Joanna has asked or said that they are implementing a trigger point within their policy. It will be a 3 occasion within 12 rolling months. There isn't a specific trigger point in the current policy. Would you disregard all absences employees have had so far and do a fresh start, or is it lawful to count them in?
No, I think, well, there's two things. But if you're amending your policy and it's non-contractual, what I would do is I would still consult with your workforce, to still consult with your employees and explain the rationale for making changes to the policy. If it were me, I think it would be more reasonable to disregard previous absences and start almost afresh from the point that the policy goes live. So if you have a particular date that you're going to launch that policy after you've met with the employees or communicated with them via email, it would probably be more reasonable to say, look, from this date moving forward, we will be looking at X triggers in a rolling 12-month period. Does that make sense?
Michelle said, we have an employee that is signed off with stress as she is looking after a frail elderly parent. What is the best way to manage it?
So did you say she signed up with stress, Jo?
Yes.
Okay, so I'm going to make some assumptions, and feel free to clarify in the chat. But if she has been signed off by a GP and she's been off for a while and it has fallen into long term, if you haven't met with her yet, get in touch, open the lines of communication, and talk to her about what's happening for her. So if she's caring for an elderly relative, you need to start understanding, what is she doing to mitigate the need for her to be away from the business, and what is she doing to put alternative care plans in place to support that relative. Because ultimately, what you want her to come back to work, feeling fit and well, and obviously not stressed. But the only way you're going to be able to start doing that is by talking to the individual. So the first step would be, arrange a meeting and start having some open conversations about, how long she envisions being away from the business, what are her plans, and then go from there, would be my advice.
Someone else has asked, what if an employee is off sick for joint pain? Then we get another certificate for work-related stress when they've not been in work.
Oh, that's interesting. So I would arrange, again, it's meeting the employee and asking the question, we're concerned you were away from the business. I'm assuming they were away medically certificated by their GP or a medical practitioner. So if that were the case, that they were medically certificated with joint pain, and that's now turned into work-related stress, I'd be asking the question, what has triggered that work-related stress? Where has that come from? Because ultimately, at the moment, as things stand, they have been had a period of absence for one condition and have now been signed off with another condition, and you need to be clear on what that about. So definitely get in touch with the employee and ask that question.
So Anna's asked, Is it appropriate to decline an adjustment on the basis of lack of finance? For example, phased returns are usually offered to employees returning from long-term absence for 4 to 6 weeks. If an employee's GP or occupational health are recommending longer, in brackets, as being led by the employee, but the employer can't afford it, i.e. they're on full pay when working reduced hours, and they have to cover the remaining hours, do they have grounds to decline the request?
Yeah, that's an interesting one. Actually, there's not a straightforward answer. I mean, I guess if you genuinely, as a business, can't afford to accommodate a phased return, then you could argue that's, you're justifying why. I suppose the only thing I'm thinking of is if the employee, again, it's hard because I've got questions, but if the employee is on full pay during that phased return, could you not meet in the middle? Could you not speak to the employer and say, look, we can't actually afford to, I mean, I'm guessing the reason why you can't afford it is perhaps because you're covering their role with an agency worker, for example, and having to pay them full pay. It's really difficult for me to give you a specific answer because there are questions I have that would help me be able to provide you with a kind of a better response. So what I would say is, feel free to email me with a specific question, and I'll come back to you with any questions, and I'll try and give you more specific answer. But what I would say is, I wouldn't automatically say that is a valid reason in isolation of maybe looking at the bigger picture, i.e., why is the employee being paid? Is it, do they have a contractual, is there something in their contract that stops you from saying to them, what was your, I guess what I'm trying to say is, what did your sick pay policies and procedures say that you can do in those situations, as an example? Feel free to come back to me, and I'll send some questions and I'll come back to you.
So Joanna's asked, is it lawful to pay in lieu for holiday when an employee remains in long-term sick?
So employees do accrue holiday while they're on long-term sick leave. Ordinarily, what we say to clients is, when the employee returns, you want to give them the opportunity to take that holiday. That being said, if they're on long-term sick leave, there's nothing stopping the employee taking that holiday during their period of absence, the sickness absence. So as long as they request it and you book that in. So often we see that with clients where the employees run out of sick pay. We've got one case at the moment where someone's medically certificated, they've had surgery, there's been complications. And so what the employee has done is they've used their holiday entitlement as a way of giving them a bit of an injection of cash whilst they're on sick leave. So I don't know if that answers your questions. What I would say is, ideally, if the employee is going to be coming back within a reasonable time period, then there's no reason why they should be able to book and take that holiday.
Okay, so Jenny's put, our attendance policy is trigger points, at which point an attendance review would be held and a formal improvement warning is potentially issued. In recent cases, I've struggled with the wording of improvement warning when someone is genuinely long-term ill and so their ability to approve their attendance is truly out of their hands. Do you have any suggestions about what we can include in our policy that would be appropriate for a formal review when someone is not well enough to consider a return to work?
Yeah, I mean, if someone's genuinely not well enough to return to work and you've got supporting medical evidence, it wouldn't be reasonable to be issuing them with improvement warnings, because ultimately, as you're rightly pointing out, they're not able to necessarily improve. So I think what you'd want to do is look at reviewing your long-term absence policy as a whole, to make sure that it's written in a way that supports people who are on long-term absence due to ill health. Again, I'm happy if you want to have a chat and we look at your absence policy, I'm happy to do that, and to give you a few points and hints and tips, as it were.
I'm not sure if we've just answered this one a little bit, Nathan, in the last one. So Samantha's saying, what would the approach be when an employee's been off sick for a long period of time and has exhausted their sickness entitlement and then asked to use some of their outstanding accrued annual leave in order to be paid? In essence, they want to take 2 weeks annual leave during a period of ongoing sickness absence.
Yeah, you can let them take use up that holiday, they obviously, as I've said, they accrue holiday during long-term sick leave, where you accrue holiday in short-term periods of absence as well. And yes, it's perfectly acceptable to take part of their holiday during their sick leave. So again, as long as they request it, you've got it in writing, they've requested it, and you're managing, tracking when that holiday's been taken. There's nothing wrong with doing that. Just keep good records.
So Anne's asked, if the person returns to work in a different role, do you have to pay them the same if the new job is on a lower pay?
Not if it's not if they agree to come back into that role as a suitable, alternative to them being able to come back to work. I think if you're facing a situation where you've got somebody on long-term sickness absence who is not able to come back to their existing role, and that is supported by medical evidence, then if you have a role that exists within the business, there's nothing wrong with saying to them, well, this is the role that exists. We can move you into that role. However, the salary for said role is X, Y, Z. That being said, I've had other clients that I've worked with who have moved people into different roles, and where the salary has been lower, they've essentially red circled their salary and said, look, you're on a higher salary. We're not going to take that away from you, but what it will mean is that you won't necessarily get any pay increases until such time that your salary falls back into line with where it should be.
So Maine has asked, at which point in time is it reasonable to terminate an employee, even with a possible return to work, but beyond what an employer would deem reasonable? How long is reasonable?
It all depends on the circumstances, and I know that's going to sound really vague, and like I'm not wanting to give you a specific answer, but reasonableness depends on the circumstances of any one particular case. Now, if they are likely, you mentioned that they're likely to make a recovery and be able to return to work. I suppose the question I'd be asking is, how long have they been away from the business, and how long is it likely to be for them to make that full recovery, and who's giving you that information? And that might help you make a reasonable decision. We've just had a case recently where, in all the circumstances, it was reasonable to dismiss an employee who'd been away from the business for, I think it was 10 months, and they were unlikely to be back for another 4. And the business said, look, we just can't sustain that anymore. We're at a point where, this is a crucial role, and we need to be making, provisions now to, have that role manned in a more consistent way. They were covering temps, for example, and temps would come and go, and so on. And so, but the employee had been away, in this particular example I'm giving, they'd been away about 10 months and weren't likely to come back for another 4. And there was some vagueness about the likelihood of that happening, that return within the 4-month period. So in that particular circumstances, the decision was made to dismiss, and they were supporting medical evidence from occupational health and so on. So the reality is, it depends on the details of your particular case. Without having knowledge of those details, I'm not able to give you a specific. Sorry.
Okay, so Shivani's asked, I have an employee that is stuck in Spain due to a motor accident for the last year. He informed us he's not fit to fly. How can I encourage him to return back to the UK for him to do a physical occupational health and for us to do a home visit?
Wow, that's a complicated one. Okay. Ideally, you would need to initially get access to medical records of the medical practitioner who's been looking after him during the last 12 months, because the challenge is going to be then whether you have to have that interpreted. Now, I have dealt with cases before where the employee, for example, hasn't played ball with giving us access to medical records, for example, or engaging with occupational health. And what we've done is we've gone to the occupational health provider that we work with, and they've basically given us a medico-legal report. And what that means is that they have taken information that we provided, information that we had available to us. It did, and we would have ideally, in this particular case, for example, that I'm giving you, ideally we would have liked to have had a medical report, but it wasn't possible in this case because the employee refused. So what we did is we set out to the occupational health the reasons for absence, and we asked a series of questions, and that occupational health provider gave us a medico-legal report, that gave their opinion as to the likelihood of that person being able to return to work. And then we relied on that information, because what we made clear to the employee is, if you don't engage with us and if you don't give us the information we feel we need to be able to support you and support a return to work, or not, as the case may be, if he's been seriously injured, he may not be able to make a recovery and return to work. But for you to make a judgment on that, you need him to cooperate with you and give you as much information as possible. So in this case, I've just given you, the employee didn't, and so we relied on an occupational health specialist who was able to give us a medico-legal report with their opinion. But what we did make clear to the employee is that, any decisions we made about their employment would be based on the information we had available to us, and we therefore urged them repeatedly to cooperate with us and give us as much information as they could. Unfortunately, they didn't, and we did end up terminating. And the outcome of that was fine. Actually, we didn't. They appealed, but the appeal upheld the original decision to terminate employment. So essentially, it just went away. But my advice would be, is to start. If you haven't done already, write to that individual and start opening up the lines of communication, saying to them, look, we need you to engage with us. And if you can't attend an in-person occupational health assessment, speak to a provider who can facilitate that being done remotely via Zoom or Teams, whatever tool that they're using.
Okay, so Corinne has said, in the absence of medical information, because the employees refused access and there is no agreement about how long the employee will be off sick, how long is it reasonable to wait before instigating dismissal? They've exhausted their sick pay.
Wait, can you just repeat that again? Because the first bit you broke up on me there.
Sorry, in the absence of medical information, because the employees refused access and there's no agreement about how long the employee will be off sick, how long is it reasonable to wait before instigating dismissal?
Again, it depends on how long they've been away from the business already, why they're away from the business. Is it, have they had an accident? Are they disabled? Again, I would need more information to give you maybe a more robust response. But my thought is, if you are asking the employee to cooperate with you and to, say, attend occupational health assessments, give you access to medical records, etc., and they're not doing so, ultimately you're going to have to get to a point where you can't leave things open-ended. You need to ultimately make a decision. And what I would be saying to the employee is, look, if, for example, you have a long-term absence policy that says, at trigger 3, excuse me, I'm fighting with the cold, I apologise, I'm going a bit croaky. If you have a long-term absence policy that says, when you get to trigger 3, that's the stage when we start thinking about, terminating employment. What you want to be saying to the employee at that stage is, look, it's in your interest to cooperate with us. If you do not, we're going to have to make decisions about your employment based on the information we have available to us today. And therefore what you do is you start building up a picture and you start documenting that you have asked consistently the employee to provide information and for them to cooperate with you, and they therefore have not. And it wouldn't be reasonable for you to continue employing them, open-ended without getting, some kind of idea about likely time it's going to take for them to make a recovery and return to work. But again, that being said, if they are signed off by a medical practitioner for a valid reason, I certainly wouldn't be making the decision to terminate early on. You'd want to follow a process that shows that you have given them adequate time to make a recovery. It might be, for example, that if they've been medically certificated with a specific condition, that you go to an occupational health specialist and ask them, excuse me, to give their opinion as to how long it would likely take for someone with that condition to make a full recovery and be able to return to work. If occupational health say, in their opinion, it would be 3 months and the employee's been off for 7 or 8, then you start to build, evidence that actually we would reasonably expect that employee to return by now, and it's not reasonable for us to continue as we are. I hope that answers your question or helps in some way.
Maria's asked, she said that she's inherited long-term sick staff, in brackets 3 years plus. Does she start absence management? They've stated they're not returning, but they're not resigning as they'll lose benefits.
Okay, well, I mean, straight away, you've got evidence of the employees not returning to work. So, I mean, again, I'd have more questions, but what I would be saying to you is if you haven't started absence management with these individuals, then you need to start doing that now. And given that they've been away from the business for 3 years, and it sounds like maybe nothing has been done to manage that situation, it might be helpful for you to get some advice on that before making any decisions to terminate employment. But certainly, if you've got in writing the employee saying, well, I'm not returning to work, but I'm not going to resign, that is, a fairly substantial piece of evidence to support that you can't continue as you are. And the individual saying, well, I'm not prepared to come back. What I would be keen to do, though, is to understand why they're not wanting to come back. So why are they away from the business? Are they medically certificated? If so, what's the health condition? And work your way forward from there. But definitely start absence management.
There's just a couple more, Nathan. So Nina's asked, how do you deal with someone who is terminally ill and not able to return to work? Do you dismiss?
So terminally ill, I mean, that's it's a tricky one, and actually there's lots of other things to consider. I mean, for example, if you've got someone that's terminally ill and they've got death in service benefit, I'd be saying no, you wouldn't want to be dismissing them, because if their terminal illness is going to result in their death in a fairly short period of time, you wouldn't want to take that course of action and then prevent them getting things like their death in service benefit. So again, my advice to you would be to take advice, but the question I would have is like, what is the condition, and how likely is that to result in them passing away within a quite a short time period? But no, I wouldn't be looking to dismiss someone that's got a terminal illness.
So I'm just jumping here because there's a question that's just come in related to that. Rebecca said, what if they've been given a terminal illness, but it's 3 to 5 years?
Oh, I mean, okay, yes, that is a very complex situation, and that's something even we would take advice on. So I'm not going to give you an answer, a specific answer on that, because that's something that even I would want to take advice on in those circumstances. And we often will work with employment lawyers in what we call really complex situations like that. Because obviously I understand from your perspective, if you've got someone with a terminal illness that's not going to return to work within a 5-year period, that's obviously going to present a number of challenges for the business, and that's not necessarily reasonable for you to absorb that. But my advice on that is take some advice.
So Nikki's asked, what's the best way to approach when an employee is not engaging with communication for welfare reviews?
Yeah, it's a really interesting one. And we deal with this a lot, and we've got a couple, or we've had a couple of cases recently where employees have just refused to have any involvement with engaging with the absence management process. And sometimes that is because they perceive the process as being a way for the business to manage them out. And actually it's not. It's a way for the business to try and get them back to work fit and healthy. What I would say is make sure that they're not signed off for things like anxiety or stress that might be facilitating their reluctance to engage with the process, because it might be they don't feel able to. But if that's not the case, then I'd be, I often ask the question, look, we're trying to reach out to you. We want to arrange to meet with you. This is about us trying to support you. You're not engaging with us. Is there a reason why? And it might be they come back and say that they have a preference in terms of how they communicate with you, and you can make adjustments therefore. So what I would do is understand from the individual what's going on for you, make it clear that the process is about supporting them. It's not a punitive process where we want to manage them out. You're wanting to get them back to work, fit and healthy and well again. So start asking those questions would be my advice.
Okay, so the last one now, and obviously I'm conscious of time anyway. An employee has been going through ill health retirement as she refuses to come back to work. She's got a disability. She now refuses to give more evidence of her illness to occupational health. Do we start the dismissal process?
We'll say that first bit again, Joe. So my line's bad. It was my.
Sorry. An employee's been going through ill health retirement as
Yep.
she refuses to come back to work and she's got a disability. She refuses to give more evidence of her illness to occupational health. So do we start the dismissal process?
Yeah, essentially, if you followed a fair process, and you've done all the things that you know, if you've got a long-term absence policy, make sure you followed that to the letter. And it sounds like you have. It sounds like you've worked with occupational health. If she's refusing to give you any more information or details around her health situation, then it might be appropriate in the circumstances for you to start thinking about, okay, if she's been off for a significantly long period of time, that you need to take steps to terminate employment. But what I would say in that regard, and I wouldn't take this as me giving you any specific advice because I haven't got all the specific information that I would need, but what I would say is that you need to make sure that, and I'm sure you probably do already, that this person, you know, that they're not disabled, and that you have exhausted looking at, you know, making reasonable adjustments and so on. So, yeah, there's nothing wrong if you've got to the point where you're saying, look, it's no longer reasonable for us to continue as we are, and you can evidence the things you've done over a significant period of time to facilitate a return to work. Then, yeah, ultimately, you know, if the person's not capable and they're not likely to make a recovery, then you need to take steps. I apologise if I sound like I'm being vague. It's not I'm being vague. I'm just conscious I don't want to give you incorrect advice because I don't have all the information. But again, feel free to email me, and we can talk about specifics, and I can give you maybe a more stronger view.
That's it from the chat box, Nathan. Anything else as a roundup from you?
No, other than I appreciate it's a really, really meaty topic. And it was a whistle-stop tour, and you may have more questions. And again, if I've sounded at all vague with some of my responses, it's not that I'm intending to be. It's more that often there's lots of questions that we ask before we give an opinion. So if you think, oh, actually, he's not really answered my question, or I'm not sure, feel free to drop me an email. I don't mind. You know, if I can, get some more information, I might be able to then answer in a more detailed way for you all. But I hope that was helpful for everyone.
There's some really good comments there, Nathan, and I've put your email address in the chat box, so I think you'll end up getting quite a few emails, which is, pretty good. So yeah, I'd just like to say thanks very much to everyone who's signed in for today's session. Massive thanks to Nathan again for facilitating the session, and another good event. We haven't got any events now until January. I will put a message into the email that I'm going to send everyone this afternoon. But otherwise, thanks very much, and thanks very much for joining us.
Thank you, everyone. And thanks, Joe.
Cheers. See you later. Bye-bye.
Bye.